very important because most of the academicians, they are well aware of the publications of papers, research papers in conferences, presentations, workshops, and everything, etc. But most of them are unaware of patents. And just we'll go one by one. April 26th is observed as World Intellectual Property Day. I think most of you are familiar with this course. So, what is this? Can anyone of you tell? Okay. Now you can see this. This is the winning pose of, after winning the race, Usain Bolt gives a gesture, winning pose. This he has filed a trademark in Jamaica and has been granted. What is the use of this? You want to make profit out of it. Worldwide people knows about this gesture. He can print on the sports goods, anything, and he can make use of it. Sachin Tendulkar, with his name and with this symbol, it's a trademark, has started a sports shop where he can sell sports goods like this. By seeing these two, we know that this is TVS, this is Bajaj. We know by seeing the symbols, letters, or any picture, we come to know that this is belonging to this company. So recently, this is much hot topic. Facebook has become Facebook Meta. What is so important in this? If you see this, Facebook owner pays around $60 million for Meta name rights. He's not buying physically anything, just he is buying rights for that name. That is the importance of this intellectual property rights. Almost all people are well aware of this issue of plagiarism of this Kantara issue. Still it is running. See, the Karnataka makers face allegations of plagiarism. Kerala banned Thaikudam Bridge to sue for copyright infringement. So if you have any innovative idea or anything related to intellectual property right, it is advised to protect it legally. So therefore, this type of problems doesn't arise. Therefore, this awareness program has been initiated. See, you have an idea, someone is stealing your idea, utilizing, exploiting, and making profit out of it. So therefore, you have to protect. If you protect, what you will get? This protection, excluding others, and commercialization, all are interlinked. Once you protect, automatically you exclude others. So once you exclude others, you can commercialize, you can earn money, you can utilize it. This is the significance of intellectual property right. What is actually intellectual property right in terms of legal definition? IP means the property which is created with intellect, idea, creative mind, such as inventions, books, paintings, songs, symbols, names, images, or designs used in businesses. A legal right conferred on such property is called intellectual property right. So therefore, it is necessary to get protection. There you can proceed legally further. So most of these IPRs are territorial in nature. That means if you have protection in India, you will get protection only in India, not in other countries. So what does intellectual property offers? In a common person view and business person view, common persons just they see the pride or academics. Okay, I have published this many papers. I found something very interesting that I will publish. We'll give to newspaper will publish the article, we'll make cutouts and we'll keep in our office rooms or laboratories, etc. But businessman, he will think how to commercialize that one, how to increase the brand value, how to earn money from that. So this is the major difference between businessman and common person. Though the intellectual property is same, idea is same, that utilization is different. So if you have an intellectual property right, you will have due recognition, awards, rewards, can earn money as royalty, incentives, etc. through technology transfer, licensing, etc. So you can sell commercially without fear of copying. So no need to fear that someone will copy my product or my good or something. because we have protection. Genuine and original products, new innovations, new markets, new business can increase the value of college, especially for our academicians. Your CV, it looks much better. Faculty members, students, it will help a lot. Economic growth of country and world is also depending upon the IPR protection. So, how many types are IP rights are there? Number one, patent. Next, design, trademark, copyright, geographical indication, semiconductor integrated circuits, layout, design. So let us see one by one. The first one is patent. What is a patent? A patent is an exclusive right granted in respect of an invention, which may be a product or a process. For example, if you have a tablet, example paracetamol, that is a product. If you find any or if you discover any formula, any formulation, any product, any chemical compound, that product you can patent if it is a novel, and the process to arrive at that product, to make that product, that process also can be made patented. That provides a new and inventive way of doing something or offers a new and inventive technical solution to a problem. In our daily life, if you face any technical problem, if you overcome it by an inventive way, that process, that product can be patented. This gives exclusive right to the patentee to stop others from making, using, exercising, vending, and importing an invention for a limited period, that is around 20 years, in exchange for disclosing it in a patent specification such that anyone trained in the art can reproduce the invention. So you are disclosing your invention, in turn you are getting the protection. So it is mutual benefit to the public and to the inventor. So it excludes the right to others to use your invention, so that other person cannot copy, he cannot sell without your permission, he has to buy from you. This is the advantage of patent. If you see this statistical slide, in China, the patent filing is 1.4 million, but in India it is 53,627 only. What is this much difference? What is making this much difference? According to the Global Innovation India Index ranking, India's position is 40. Though we have this much population, in invention wise, India is still behind. The reason is there is no awareness among the people. Though people are very creative, though there are many ideas, people doesn't know how to get protection, where to approach. So this is the program organized to create awareness among the people, so that people can come forward, they can take research, whatever the idea they have, they can get protected, so that the economy will increase. When we talk patent, we think that some great research, very high-end research we will be thinking. That comes into our mind. But always it's not the case. As I said, any product, any process, if it solves an existing problem in an innovative way, that can be patented. Simple to complex. A simple article that is preventing that going water into the eyes of the baby. These are the foldable hangers, pacemaker, and an engine. Anything can be patented. See, all of you must be familiar with this one, Michael Jackson's anti-gravity limb. The reason behind this step is, this is the shoe. Michael Jackson just not a dancer, he is an inventor also. So details regarding his invention and this shoe are available in this application. Simply you can type Google patents, you can type this number, enter, thing will come. This is another invention, illuminating helmet. Cyclists who are going on road, they can indicate left or right And one more advantageous thing about this is, if they meet with an accident, that sends the signals to the nearest and dearest people, emergency purposes also. So inventions can vary from simple products to complex products. Most of you are aware of this one. During a match, after winning, then captain Indian captain Dhoni was trying to take these stumps, but umpire denied because its cost is said to cost is 30 lakhs. That much cost, what it is making means it is patented. The details of this patent you can find in this application by typing this number in Google Patents. Just not that much complex innovations, simple things also can be patented. A school-going boy from Tamil Nadu has filed a patent for this article. When Adi suffered a fracture in his hand, he had to wear a cast and a sling to support his fractured arm. We know that anyone meets with an accident to hand, this happens everywhere. Wearing the sling for about 16 hours a day, along with all the weight of the cast on his left shoulder, caused a lot of pain. Therefore, he thought of putting an appendage around the waist. Now, this is under processing. We are all well known about this one, Graham Bell, for his discovery of telephone. So this is the evolution of telephone. Now everyone uses smartphone. If you read this one, Alexander Graham Bell applied for a patent for the telephone on February 14, 1876. In 1876, he applied. In India, still we are in awareness programs. Only a few hours before, another inventor named Elisha Gray handed in his application for a telephone as well. Just before a day, he applied. Had Bell waited one more day to apply for a patent, Elisha Gray would today be considered as the inventor of the telephone. So why I want to stress here is, you have an idea, if you keep it with you, someone will come with the same idea, with similar idea, he will get the protection, and you have to remain silent. The next IP right is designs. I think most of you identify this. You can identify. What is this? It's a Harpic bottle. Nothing has been written on this one, no label, but still we are able to identify that this is Harpic bottle. How? Based on the design. In our daily life, we got familiarized with this design. So what are designs? Designs are features of a shape, configuration, pattern, ornament, or composition of lines or colors applied to any article. See these designs, whether in two-dimensional or three-dimensional or in both forms, by any industrial processes or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. So these comes under designs. Different shapes of the bottle, different design, lines, and an article, a toy. So these things can proceed with the design protection. Not only that, different designs of the dresses also can be protected. You can see various designs. Most of the times they will be talking designer and all these things, they get protected. Here if you see, just a Dow company itself has made different shapes of bottles. What is the need of doing these many shapes? Making, you want to prevent others from making these shapes. So he is getting protection here. Simultaneously, he is preventing others. You can see all different kinds of shapes of bottles. All these things will get protected. Once you get protection, others cannot reproduce this. The next one is trademark. A sign capable of distinguishing the goods or services of one enterprise from those of other enterprises is known as trademark. We know that branded, everywhere we talk about branded. Here no name, but still we recognize and identify it as Nike. That is the value of trademark. It is trading under this trademark. Adidas, Puma, McDonald's, this one Domino's, Pizza Hut, all these things, just a symbol making their trade business. What subject matter can be trademarked? Any brand name, taglines or slogans, sound marks, here lion roaring, logos, combination of colors, Nike, just to do it. They can make it as a trademark. LG, Life's Good, Coca-Cola, Open Happiness, like this. What is the importance of this trademark means? It is just not a name or symbol or logo. It's actually the identity of the brand. It distinguishes the source of the goods or services of one trader from those of others. Allows a business entity to build public goodwill and brand reputation. It assures customers about quality of goods or services. So if any one of you having a thought of starting a startup in future, make sure that you have a trademark so that your business runs very smoothly. How to know whether it is registered or not? If any Tetra Pak or any item, if it is symbolized with TM means trademark application has been filed. It is under process. If this symbol is there, it is a registered trademark. You can distinguish the articles based on these two symbols. See, regularly we see in the markets, instead of Puma, it will be Puma. Sometimes Adidas, Abibas, Bisleri, Bisberry. So he can't copy it. Bisleri got protection, Puma got protection. So they can't sell under the same name. That's why these people are trying different names. The other one is copyright. Most of you are well aware of, must be aware of this one. Copyright is an exclusive legal right granted to creators on expression of an idea. Copyright owner has right to reproduce, translate, adapt, perform, distribute, and publicly display the work, etc. Registration is not mandatory for this. Since copyright comes into existence as soon as the intellectual work is created, like a movie or any song, soon coming into the picture, it gets protected. But it is recommended to register a copyright for better enforceability, since registered copyrights have evidently value in court. This is the symbol that it has copyright. What things can be copyrighted? Any literary work, painting, photographs, drawings, films, music, choreography, sculpture, etc. can be copyrighted. What is the terms? All these things will get 60 years from the work, and this literary work will get from the lifetime of the author and until 60 years from the death of the author. The another one is which comes under designs is semiconductor integrated circuit layout designs registry. It is chips which is present in mobile phones or remotes, etc. The other one is geographical indication. The name itself is telling you that any product is originating from a particular place, then we give it as a geographical indication. A geographical indication is a sign used on products that have a specific geographical origin and possesses qualities or a reputation that are due to that origin. Edayur Chelli, so people will talk about this carries the place of origin, the name of this product. Tirupati Laddu, Maddalam Palakkad, Mysore Sandal Soap, Kanchipuram Silk, Neelambur Teak, Dindigal Locks, Kashmir Saffron, Kovilpatti Kadla Mithai, Pokkali Rice, Darjeeling Tea, Kodaikanal Hill Garlic. All these things comes under geographical indications. So in daily life, we may be using many items we are using, but we don't know that all of them have a protection. For example, if you take an Apple laptop, all these intellectual property rights can be observed. LED display comes under patent, Body of laptop comes under design. This Apple sign comes under trademark. User manual comes under copyright. Layout of integrated circuit comes under design. Can you identify how many patents are there? How many IP rights are present in this picture? You can answer if anyone identifies. If anyone identifies, you can answer. Okay. So teacup, it comes under design. Tea, it is a specific composition, a product. This comes under a patent. If it is a Three Roses or Taj Mahal, then it comes under trade name. If they give anything instruction how to prepare a tea, then it comes under copyright. So what is the validity of all these IP rights? Patents, it is 20 years term. There is nothing called global or international patent. All patents are territorial. Designs 10 years plus 5 years. Trademarks indefinitely. Geographical indication indefinitely subject to renewal. You have to renewal after 10 years. Copyright lifetime of the author, then additional 60 years. Who can apply? Any person except GI. For all IP rights, any person or legal representative can apply. Any person means a firm, company, any partnership, small entity, and a body corporate, any startup company can be considered as a person. So these are the validity periods. In summary, patents will be given to inventions, product or process for about 20 years. Designs, any aesthetic or ornamental and non-functional features of an article or product, 10 plus 5 renewable. Trademarks, distinctive signs or marks to identify and distinguish goods or services. It is indefinitely duration, renewable every 10 years. Copyright, artistic, literary and musical works, sound recordings, films and broadcast derivative works, lifetime of the author plus 60 years, remaining other copyrighted items for about 60 years. Geographical indication, a product originating from a specific location which gives that product a unique and differentiating quality. It is indefinite, renewable every 10 years. This for chips, it is 10 years. So these are the points to remember. If you have any idea, first you protect, then only you publish into the public domain. Registration is done by sovereign authority, Government of India. You should approach respective offices. Right for limited period of time. As I said, for patent 20 years, like that. No automatic relief. That means if someone is infringing, you have to file infringement suit in district or high court. Renewal fees to be paid for some IPRs. I hope you grasped a few things. Based on this, I would like to give a small quiz. Please read it carefully and try to answer it. You can answer. Which type of IP protects the painting painted by artists? Okay. Painting, it comes under copyright. What protects the intellectual property created by fashion? Yes. Right. What protects the intellectual property created by fashion designers? What protects the intellectual property created by fashion designers? Anyone can answer.
Registered designs.
Yes, exactly correct. The next one. What protects the advanced disc brake for bike developed by the inventors?
Trademark.
No. It is disc brake. Copyright means any literary work painting something. Okay, someone answering. Geographical indication means it is particularly originating from one particular place.
Patents.
Patents. Excellent. Patents. Next one. Which of these is a geographical indication?
Haitani Sari.
Yes, yes. Very nice. What does a trademark protect?
Third one.
Logos, names, and brands.
Excellent. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work?
Copyright.
Nice. Very good. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? In initial
Registered
stage,
designs.
excellent. No. Trademarks. Design, it will have particular design. For example, Sachin Tendulkar, he wanted to start a company with his name Sachin Tendulkar and a ball symbol. That comes under trademarks. Design, it comes as a shape. For example, a bottle or any mobile phone shape or that. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention?
Patent.
Patent. Nice. Okay, now where to go? Which office to approach? So as I said in the beginning, the patent office functions under the Ministry of Commerce and Industry, the Department of Office of Controller General of Patents, Designs and Trademarks. Patent office present in Kolkata, Delhi, Chennai, Mumbai. Designs office is present in Kolkata. Trademarks registry present in Mumbai, Delhi, Kolkata, Chennai, Ahmedabad. GI is present in Chennai. Copyright registry is present in Delhi, and the SCI/CLD registry is present in Delhi. In Nagpur, awareness program, public information system, everything is present in Nagpur. So what is the procedure of filing? See, Chennai office covers Andhra Pradesh, Telangana, Karnataka, Kerala, Tamil Nadu, and Union Territories. If you are approaching office directly, physically, then if you are residing in these states, you can approach Chennai because these are the jurisdictions. Physical filing, submission of hard copy in the appropriate patent office. either in Chennai or Kolkata or anything, through post or direct or in person also can apply. Online e-filing through portal, this site. So for online filing, one has to use e-signature. So submission of hard copy in the appropriate patent office, it is not available for patent agents. Patent agents can file only through online, but any individual person can file either hard copy or soft copy. So this, if you go to this site, this page of web page appears. Here you will have all the information related to patents, designs, trademarks, geographical indication, any training programs. In patents also, if you click here, whatever the doubts you have frequently asked questions, they will be there here, everything procedure. If you go here comprehensive e-filing will come. So if you click that, you will come here. Here you can register with your login ID and password. Related to patents, acts, rules. What type of acts are there? What are the rules and manuals, guidelines? For our knowledge, it will be available openly for the public. And every week, office publishes journals. The accepted patents, published patents, who have filed for the patents. So anyone interested can access this and they can read what type of patents are being filed. So what type of applications are there? Ordinary application. Any person residing in India, if he files in India, then it is called ordinary or domestic application. If any convention country, from foreign country, if they file in India, then it's called convention. And PCT, it is under treaty, patent cooperative treaty. If they file under this, it is called PCT. And here you filed a patent, for example. After filing, you came to know that you can improve your product. For example, a medicine, okay, you understood that by adding another ingredient, it is giving better results. So you can modify. So you can add something to that. That's why it is called patent of addition. And after filing a patent, you have filed many things and the controllers have said, no, here more than one inventions are there. So you have to divide. Then you can divide the application. Then it is called divisional application. And afterwards, if any professor or scientist, a student who is doing a research, he had an idea, a preliminary idea, which he thought that he can file for patent, and it may take few more months to develop. In that circumstances, he can file a provisional patent so that it secures your priority date. So that, for example, today you file a provisional application, it comes into the effect from today onwards. You will be given another 12 months to file complete specification, your complete data. So this is provisional and complete specification. If you have any doubt regarding these things, you can ask me later. So what are the forms are required to file? Number one, form 1, application form with your details, name, your invention title, email ID, mobile number, your address of service, where to send these details, etc. will be there in form 1. Form 2, it is completely technical. Your invention, including title, abstract, description, if any drawings, figures, that one, and claims. Then statement of foreign filing. If you file anything in foreign countries, you have to give that information to the office in this form. After filing, you have to request to examine your application by filing this form. These forms are not required all the times. If you are filing through an agent, then power of attorney. You should give power of attorney to that agent to file that application on behalf of you. Proof of right. You are the inventor, you are giving that invention to a company, then you should give a proof of right to that company to file. So these are the fees for the patent. It is 1600 rupees for normal person, and no fees for up to 30 pages. If you have your description up to 30 pages, no fees. If you have 10 claims, no fees. If it exceeds, then additional fee. So natural person, as I said, a person, a firm or any entity, startup, any college, government recognized college or aided college, anything, it comes under normal person. So they can file with minimum 1600 rupees, and for examination 4000 rupees. In 5600 rupees, we can file for a patent. In some circumstances, examination can be done early. That is called expedited examination. Who are eligible to file for expedited examination? Any startup company, any small entity. If applicant is a female, and Department of Government, other government establishes. So these things, firms, these persons can file for the expedited examination. Once filing, you can search your patent under which stage it is. So here patent search, as I said, in home page, if you go to patent search, a page comes like this. Here you can enter application number, then it comes here, okay, you have filed or Q filed, it has been published, it is under examination, like that. You can check your this thing. So the normal examination process, it is like this. First, whether you have filed all the forms or not, 1, 2, 3, 5, 18, all are not there. If they are not, then they will raise the objections. They will check it is formal examination, whether you have paid fee or not, whether proof of right is there or not, power of attorney is there or not. Then they'll check these things. This is formal examination. After that, they check the technical examination. What is your invention? What you are claiming for? Whether it is novel or not? Whether it is inventive or not? Whether it is industrially applicable or not? So based on these things, they examine, and the gist of the objections are communicated to the applicant. This is first examination report, FERQ. So you will be given time of 6 months to reply. So subsequent examination and reply of the applicant. Once you file the reply for these objections, the examination can be done. So they re-examine and then re-communicate if there are still any objections. If all the objections are meeting and if controller is satisfied that it is new and inventive, then he can go for grant. Otherwise, if he thinks that there are still some technical objections are there, then they can generate a hearing. You can talk to controller, coming to office or video conference. You can tell what actually what is your invention, so that they will. It is a better way of communication. So based on that, grant or refusal can be recommended. So this is the sample of patent certificate. This is the design certificate. This is copyright, and this is trademark certificate. So this is for the participant certificate. This one. Thank you. If you have any doubts regarding these things, or if you want to know more anything, you can freely ask. I thank MES Ponnani College and organizers for this wonderful session. Thank you very much, Madam and Sir. Now it is open.
Thank you, sir.
for the questions.
The session is open for discussion. Also, dear participants, don't forget to fill the feedback form that is provided in the chat box. Is there any queries or questions? Sir, in the chat box, there is a question by Mr. Rafi. His question is, if we make slight changes to the logo of a company for our use, will come under IPR.
You are asking about logo.
Is Mr. Mohammed Rafi sir is present here? I think he is asking about logo.
Yeah, logo it comes under IPR. If you are having any logo, if it is new, you can file for that. If anyone is already using similar logo, then you can't get it.
Sir, he is asking that if we make slight changes to the logo of any other company, will it come
No,
under
no.
IPR? Okay.
If it is affecting, for example, Nike is there, logo like tick market is there. If you make very slight change, means it is very minute, right?
I think so.
There should be enough differentiation.
Okay, sir. I think it is clear for the audience. Any other questions?
I invite the head of the department, Ms. Soumya, for delivering vote of thanks.
Thank you, Dr. Vandana. First of all, I would like to thank Dr. Venugopal for a very informative session upon this IPR, IPR as well as the patents and the patent filing. Thank you, sir. Thank you very much for spending your valuable time with us. Next, I would like to thank our dear principal, Dr. Vijay Amira, for giving permission for doing conducting this session. Thank you, ma'am. I would like to thank Dr. Jairam, the IAC president of our college, for presiding the function. I also take this opportunity to thank Ms. Lavanya and the whole NIPAM team for helping us or for making this session possible. So she is very helpful for us. So thank you, Lavanya and the whole NIPAM team for conducting this session, for providing this session, especially for science to us. I would like to thank Mr. Julfar for technical support. Uh, I also thank all the participants from other colleges, as well as the participants and students of our college, MES Panani College. I thank everyone for your participation. I think this session will be very helpful for us all. Thank you, sir. Thank you very much. The participants, please fill the feedback form before you leaving.